Hi friends, today we are going to discuss about legal issues in suicide and attempted suicide. Myself, Dr. Suresh Padadmat, Professor of Psychiatry, Niman's Bangalore. This, we'll discuss about suicide. Suicide is nothing but a self-harm. So the motive for all suicide or a self-harm, there will be one or the other motive. One is self, because of certain reasons, have done something wrong and I am being guilty, I want to commit suicide. So that kind of thing is a deliberate one. Whereas another one is an abatement. Somebody is pushing me to do it. So that is abatement. Another one is deliberate. So all kind of suicide or attempted suicide, there will be one or the other reason. Now the issue is whether is it deliberate, whether it is an abatement. As per legally, what entitles to be called as abatement is the issue which the legal discussion or legal discourse takes place. Coming to the deliberate one. Deliberate has three types. Suicide, which is completed. Another one is attempted suicide. The rest, the other things will be miscellaneous like religious rituals. In some of the religion, the people wants to attain nirvana by giving up food. So in certain communities, they are there. Mercy killing, or what we call it as euthanasia, is the other one. So we will, two of these issues I will touch upon very lightly, but however, there will be a separate video will be dedicated for that. Abatement again, abatement of suicide, attempted suicide. So these are the crux of the today's discussion. Deliberate self-harm. So deliberate self-harm, there are three types: suicide, attempted suicide, and religious rituals and euthanasia. Those are the things we are going to discuss now. Coming to suicide. Suicide is completed, the person is no more, the law cannot do anything. And it is a deliberate one. Hence, that is the end of the story. Coming to the attempted suicide. Here the person deliberately has tried to commit suicide, but he is unable to complete it and he has failed the attempt. So in such a scenario, Indian Penal Code, which was drafted by Lord Macaulay in somewhere around 1852, that is in 18th century, there, during that time, the person who has attempted suicide, and then again it is the Britishers which they have brought into India, whoever has attempted suicide should be punished. And not only that, even their family was punished, his property was taken and confiscated by the government during that period. And unfortunately, we continue to use this section till date. That's the unfortunate thing what we are doing. But however, the same Britishers have repealed their act in 1960. Attempted suicide is no more a punishable crime in UK. But in India, still we have. What does it say? Section 309 IPC clearly says, whoever attempts to commit suicide and fails shall be punished for a term of 1 year with or without fine. That means you try to commit suicide and you fail, you will be punishable and you will be booked under 309 IPC. It's so funny. But however, in 2017, Mental Health Care Act slightly modified it. What does it say? Mental Health Care Act 2017, Section 115 clearly said that whoever attempted suicide shall be presumed to have stress and they will not be charged under Section 309 IPC. But however, still, if the police is able to prove that this person is manipulating or using this attempted suicide to try and manipulate the situation, still Section 309 IPC will be applicable. That means Section 309 IPC is not completely squashed. It only says that whoever attempts suicide will be presumed by default as a stress and the charges cannot be pressed. That's the way it goes. However, Section 115 subsection 2 also makes an obligation on the government that whoever attempted suicide shall be provided care, treatment and rehabilitation to that person so that these suicidal attempt can be decreased and reduce the risk of attempt again. So there has been a paradigm shift after Section 115 of Mental Health Care Act has come. Before 2017, there was a punishable offense. Now after 2017, as per Section 15, it clearly said that the government will be responsible for providing care and no charges will be pressed unless it has been proved that it is not because of stress. So other types of attempted suicides. First and the foremost is religious rituals, and interestingly, Rajasthan High Court had given a punishment for a religious ritual who attempted suicide by stop having food. That is one issue, but however, the Supreme Court has given a stay and still the case is going on and it's sub judice. We will not discuss about this. Coming to the mercy killing or euthanasia, there are two landmark decisions which has been taken in Supreme Court. One is Aruna Shanbag, that the decision was given in 7th of March 2011, and the other one is Common Cause versus Union of India, that was in 9th March 2018. These two are the landmark decision how the euthanasia or the mercy killing can be considered. But I'm not going to enter into the discussion here. We will have a separate video for that. Know about that, please do subscribe to our channel. Coming to the abatement of deliberate self-harm. That is basically, till now we discussed about deliberate. Now we are going to discuss about the abatement. So abatement, there are two types: abating a suicide, abating an attempted suicide. It's basically if somebody is pushed to commit suicide, one. Second one is somebody is pushed to commit suicide but he fails, that is attempted suicide. Abatement is there. So here now coming to, there are two important sections under Indian Penal Code, section 305 and section 306. What does section 305 talks about? It is abatement of a child, person with mental illness, person with mental retardation or what we call it as intellectual disability, or a person with substance intoxication, or a delirious person. If these persons have been pushed to commit suicide, section 305 IPC will be applicable to person who has abated. And this is punishable extending up to 10 years of imprisonment with or without fine. So 305 is a more severe one. But however, if a normal person is pushed to commit suicide, it will be considered under section 306 IPC. Here also the life imprisonment is there or a 10 years imprisonment, and it will be considered here. Unfortunately, abatement has not been defined either in section 305 or 306. To understand the legal definition of abatement, we have to read section 107 IPC. As per section 107 IPC, there are three important points have been noted for abatement. First, instigating any person to do a certain thing. That is mental instigation. Second one is engaging with one or more people in a conspiracy for doing certain thing. That is basically criminal act. Or intentionally aiding a person to commit something. So these are the three abatements which have been discussed under section 107 IPC. Further, section 109 IPC talks about if there is an abatement for a crime, but there is no provision for punishment has been made, the punishment which was supposed to be done as a crime and the abatement will be the same quantum of punishment will be given. That's what the 109 IPC talks about. Ladies and gentlemen, please understand. Understanding 107, 109 IPC is a very complex phenomena. And these definitions have been interpreted in various Supreme Court judgments. So we will discuss some of the important landmark Supreme Court judgment with regard to abatement. But let me remind you one thing. I'll be discussing certain cases. And in these cases, the names will be taken. And the confidentiality will be broken. And these are all reportable cases and they are available online. So the confidentiality clause do not applicable here. The first landmark judgment is Ramesh Kumar versus State of Chhattisgarh. This is again a fight between husband and wife. In this case, Ramesh Kumar and Chheena, they are married for a long time. But however, they have frequent fights. In this fight, the Ramesh used to demand certain dowry. On one fine day, the fight became so intense. Ramesh, in a fit of anger, says that, go and die somewhere. And he walks away. Chheena Devi writes a suicide note. She pours a kerosene on herself and she tries to kill herself by attempting suicide. Luckily, somebody sees her. She's taken to the hospital, but she has sustained a lot of burns on her body. In the hospital, she even gives a dying declaration that her husband is responsible for it. And she dies. Ladies and gentlemen, now there are two important cases have been pressed against Mr. Ramesh. One is 306 IPC, that is abatement of suicide. Another one is 498A, that is dowry harassment leading to death. So now this case reaches the Supreme Court. In the Supreme Court, when they discussed about did this there was any abatement. In the discussion, Supreme Court was categorically clearly said that without a positive act on the part of the accused to instigate or to aid in committing suicide, conviction cannot be sustained. Though there was a dying declaration, though there was a suicide note, 306 IPC was not pressed. Abatement was not being able to prove. But however, the proof was on 498A. So 3-year imprisonment was kept. Similarly, in another interesting case, Sanjay Singh versus State of MP in 2002. This is also a Supreme Court judgment. In this case, Sanjay Singh, basically his sister is married to Bhushan Singh. The Bhushan Singh and his wife, they are staying for nearly a few years, and after that there will be a fight between Bhushan Singh and his wife, and the wife goes and stays with her brother, that is Sanjay Singh. And after a few days, the Chandra Singh doesn't turn up. So what does Sanjay Singh does is he goes to the Chandra Singh's family, that is father and mother, and says that please take back my sister, don't harass her for any dowry harassment, please don't do this. And at the same time, he will threaten them with a dowry harassment case. Now, this happens on 25th July. The threatening. And subsequently, Chandra Bhushan Singh comes to know about this. After 2 days, Chandra Singh, what he does is, he will write a suicide note telling that I am committing suicide because there has been a harassment by Sanjay Singh, telling that he will put a dowry harassment case against me and my family. And I am very hurtful about this. And I am committing suicide, directly implicating Sanjay Singh. And he commits suicide. And he is found hanged. And this is an unfortunate case. Now, Sanjay Singh is arrested, that his wife's brother is arrested. And whether there was an abatement was an issue was discussed again in the Supreme Court in this case. Ladies and gentlemen, in that case also, the abatement was not being able to prove. And they said that the person was very sensitive and he committed suicide on his own. So the abatement case was clearly removed. Coming to the next, another interesting case which occurred in 2019 is the state of West Bengal versus Indrajit Kundu. In this, a very interesting case, a young girl she's an artist, she wanted to learn English. So the parents hire an English teacher who is a male, comes to their house and she is teaching English to this girl. Both of them fall in love and they want to get married. So the boy takes this girl to his parents' house and he introduces his parents. So the parents do not like this girl. Immediately there is a fight between the girl and the parents. In a heat of argument, the boy's parents tell this girl, you are a call girl. How can we take you as a daughter-in-law? The girl becomes very upset. She goes back to her parents' house and in the night she writes a detailed suicide note implicating her boyfriend's parents are the responsible for her and she commits suicide. Ladies and gentlemen, now the boy's parents have been arrested, telling that there is an abatement of suicide. This case was discussed in 2019 by the Supreme Court. Supreme Court categorically said that this, by saying a call girl or by naming somebody, does not mean abatement of suicide. And the case was quashed. Abatement has certain qualities to be proved. There should be a motivation. There should be a physical act of pushing somebody to commit a suicide or committing attempted suicide. So that was discussed in this case. The other important case, which is again a very landmark judgment according to me, Chheena versus Vijay Kumar Mahajan, which was decided in 2010 by the Supreme Court. This is a very interesting case because this occurred in the law school in one of the well-known Guru Nanak Dev University. In this law school, the final year students, they are writing the exam. After exam or some test, once they finish, they come out, a mobile phone is missing. They found that there are two people were alleged that they are stolen, Saurav Mahajan and Harminder Singh. And immediately HOD calls both of them, Saurav Mahajan and Harminder Singh. They ask them to give in writing their explanation about the missing mobile. Saurav Mahajan says, I have not done this. It is the work of Harminder Singh. Both of them give their written explanation. So the HOD takes both the explanation and he forwards it to the security officer. That is basically a Chheena. Chheena again discusses about both of them what is happening, what has happened. And they said, I will take a decision, you go back to home. Ladies and gentlemen, this happened on 13/10/2003. The boy, Saurav Mahajan, becomes very upset. And he's a very sensitive boy. What he does is he writes a detailed suicide note telling that I have not done this. Don't implicate me. I'm an innocent boy. And this, whatever is done by is Harminder Singh. And I'm very upset with the HOD and the Chheena security officer who have not done the investigation properly before the verdict came, before they did anything. So he writes a suicidal note and he jumps in front of the running train. He kills himself. Ladies and gentlemen, now again, the suicide case, abatement of suicide case has been pressed against HOD, security officer. Again, in this case, the Supreme Court was categorically said that this does not amount for abatement. The HOD was doing his duty, security officer was doing his duty, and the accused were two people. And this boy, Saurav Mahajan, unfortunately is a very sensitive guy, and he killed himself. And even though there was a suicidal note naming them, the Supreme Court said this does not amount to abatement, and clearly said that in order to convict a person under Section 306 IPC, a clear mens rea to commit the offence should be there. That means there should be a clear motivation to push a person to commit suicide. And also it says that there should be an active act. That means there will be a direct physical action pushing to do something, commit a suicide should be there. And there should be no option left to the victim that he has to commit suicide. That means this boy still had an option to appeal to the police station, go to the court, go to the various other options, but there was options were left, and this boy took an extreme step, committing suicide. Hence, the case was squashed. Both the security guard and the HOD were not pressed with 306 IPC. Another one important case I would like to bring in here is Gangula Mohan Reddy versus State of Andhra Pradesh, 2010. This is of a different category of relationship. Here, the owner of a house accuses his servant of stealing 7,000 rupees worth. He will harass him, telling that give me my money back. He will even there will be a fight between the owner and the servant. The servant becomes very upset, writes a suicidal note against the owner, and he commits suicide. Now again, Gangula Mohan Reddy has been accused of abatement of suicide. Even in this case, again, the Supreme Court said that the owner has pressed the accusation. There was no abatement. This boy, again the servant, unfortunately being very sensitive, he took an extreme measure. He had various options to go and seek help, and he did not seek help. All options were not what we call it as being exhausted. Hence again, the abatement was removed. To conclude, my dear friends, abatement means first and the foremost, suicide or attempted suicide should be established by the prosecution. There should be mens rea. That means there should be a mental attitude to push somebody to commit suicide. That means there should be a very bad intention or a gain by pushing somebody for committing a suicide or attempted suicide. And also, whatever harassment what we are talking about should be, there will be a temporal correlation should be there. Somebody did the harassment around long back, around 1 year back, and now somebody is committing suicide. Temporal correlation does not occur. Then also it says that abatement doesn't occur. There should be a clear correlation. They have harassed and immediately the attempted or committed suicide occurs. The abatement involves a mental process of instigating a person, intentionally aiding a person also, That means there should be some physical act also by pushing a person to commit suicide or attempted suicide. Further, without any positive act on the part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. The deceased commits suicide should left with no option. If there is still options are there, Supreme Court will not take it very easily. Please do remember, just because there is a suicide note or a dying declaration, it cannot fulfill the abatement definition. It has to go through the judicial scrutiny, whether the abatement fulfills the criteria under Indian Penal Code. And in one of the Supreme Court latest judgment, it clearly said each person has his own idea of self-esteem and self-respect. So this Section 306 IPC cannot use a straight jacket formula of dealing about abatement of suicide and the definition of abatement. Each case has to be decided on the basis of the facts and circumstances. That's what the Supreme Court found. So ladies and gentlemen, please do remember, abatement requires an physical act. There should be a very clear temporal correlation. There should be a clear motivation. Mens rea should be there. So if all of these are there, the judicial scrutiny should occur. Then only the abatement will be established. To conclude, my dear friends, the attempted suicide. For every attempted suicide, there will be one or the other stressors. However, please do remember, currently, Section 309 IPC is not a punishable offense. All attempted suicide will be considered because of stress. But however, still the police is able to prove that it is not because of stress, it still holds good. Section 309 IPC still is there. And for abatement, it has to go through judicial scrutiny. If you like this video, please do subscribe to my channel. Thank you very much. Stay safe.